Barbara has been an attorney since 1995. She was born in Porto, where she currently resides. She has vast experience in civil law, insurance law, where she's represented Portugal's major insurance companies, as well as property law. And she has been practicing mainly property law over the past 7 years now for individual clients, investors, companies, and real estate agents.
I will start to say that it is advisable when you, of course, are buying a property in Portugal to have with you qualified professionals, such as licensed real estate agents and lawyers that can really be there for you and advise you in all the legal aspects. I will start to explain the major steps of buying a property in Portugal. Normally, if you find a property that you want to buy, you start to making an offer, of course, and I always advise this offer to be in written. If you are serious about it, do it in a written form, and then of course the other party will accept or not. In some cases, if you are buying with the intervention of a real estate agency, some agencies will ask you for a reservation. Not all the agencies do like that, and if they do, you have to be very careful because sometimes you do like a deposit, and you will be asked to make a deposit, and still you don't know the conditions of the promissory contract that normally is the following step. So I always advise you to ask for a reservation agreement in written, so that you can fully be aware of all the conditions of the reservation agreement, and not just give money, make a deposit, a reservation deposit, and not know what are the conditions, because it may occur that you can lose the reservation deposit if you then don't want to buy, because you discover the property has some issues, or you don't want to buy, and you can even lose that money if the reservation agreement doesn't protect you. Okay, and this is a very important thing to have in mind when you are buying a property. Then normally, and then I will talk about it later, you have normally to sign a promissory contract of purchase and sale. This is not a compulsory. If everything is, if the documents are all ready to proceed, you can immediately schedule a deed and sign a deed. And then there is the registry of the acquisition at the land registry office. Those are the major steps that you have to follow when you are buying a property. So now I will talk a little bit about the promissory contract of purchase and sale, because this is a very important step. This is really where you really need someone to help you, a lawyer, a solicitor that can really help you negotiating all the clauses and be sure that you are protected and that you are safe when you sign this promissory contract. So there are certain elements that need to be there. Of course, you need the full identification of the parties, and then you must have all the property details, the location, if it is for if it is a residential property, if it is for services, all the identification, all the elements that can really identify the property. and if it has any mortgage or not, and liens over the property, and of course the purchase price and the form of payment. And here you have to be very careful, because normally you are people will ask you to make a down payment. There is not a fixed rule. Normally this down payment, it can be 10% of the purchase price, or it can be 20, 30%. It's normally a percentage, but there is not a fixed rule. So it depends on the negotiation of the parties. And you have to be comfortable with a time limit to make this down payment. If you have the money abroad in a American bank account, for instance, you need the time to transfer the money. You need to be comfortable with all the time limits that are fixed on the promissory contract. And then you have also the time limit to conclude the sale, the purchase, and you have the moment of when the property is delivered to you. It can be with normally it's with the final contract, with the deed, but it can be with upon the signing of the promissory contract. And then you can have some suspensive or resolutive conditions, like preemptive rights, which I'm going to talk about it later. So you need to have all the information, at least be aware of that, because our civil code sets some rules about the penalties that you have to obey in the event of a non-compliance of the promissory contract. So in Portugal, if the buyer does not fulfill the contract, he will lose the down payment. So the down payment will be lost, and the seller will keep the down payment that he has received. If it is the seller that does not fulfill the contract, the buyer has the right to ask to have the restitution in twofold of the amount delivered as a down payment. So this is a rule that is set, it's in our civil code, okay? If there is a delay in fulfilling the contract, you can go to court and ask for an execution of the agreement, of the promissory contract. Of course, if there is a real estate agency in the business, it has to be identified also in the promissory contract, and after that in the deed. And then you can state all the clauses that you need to be there so that you can be protected, like if there is any furniture included and any equipment, things like that. And if you are a foreigner, you must have the promissory contract translated into your native language so that you can fully understand it. And then you make the deed. The sale deed can take place at the notary office, or can be made by a lawyer or solicitor in a private document authenticated. And of course, if you don't speak Portuguese, you will need a translator in the deed that is there. It will be there. The identification of the translator will be in the text of the deed, and he has to translate verbally all the terms to you of the sale deed. And then I will talk a little bit about the documents that you need to be aware when you are buying a property in Portugal. You need all of course, all the civil and tax identification documents of the parties. And there are two main documents when you are talking about a property in Portugal. One is, we call it Caderneta Predial, a property booklet. This is a document issued by the tax authority. And then you have another document that is, we call Certidão do Registro Predial. That's a land registry certificate. It is issued by the Property Registry Office, La Conservatória do Registro Predial. Those two documents are very important and they have to match. That is to say, the areas, the location, as they need to be the same. Sometimes they are not, and that is an issue, because then the notary will not make the deed because of that. And sometimes, for instance, Caderneta Predial is not updated. The location, it's not correct. The numbers, they don't match. So you have to be very careful, even with the areas, the square meters. Sometimes they are not correct. And this happens quite often. So you need to check if there are any mortgage, register usufruct, pending registrations, because it can happen that you cannot buy the property without paying any liens or encumbrances. And also this need to be checked. And the document also, both documents need to be updated. Sometimes the seller can show you a document that it's not updated. It has a date that is very old. It's not the current date. You need always to certify yourself that everything is in order. Then you have the usage license. The usage license is always needs to exist. If your property was built after August 1951, if it was built before, you don't have you don't need it. It's not mandatory. Although there are some cases that you have a property that was built before August 1951, but it has suffered works that change the property, and then the city wall will say that it's not legal. It needs to have the approval of the city wall, because they changed the property along the years, and then can be an issue. And then you have the energy and indoor air quality of building certificate. That you always need this. Only if it is like a ruin, you would need a document that states that it's not possible to issue a certificate of this type, but you always need a document that specifies this exemption of the energy and indoor air quality of building certificate. And then you have the housing technical data sheet. This is a document that indicates the main technical and functional characteristics of the property. That only if you only need this if the property has a user's license issued after the 13th of March of 2004. And then if you are buying an apartment, you need the declaration of non-debt of the condominium, listing the condominium expenses. Or if you are buying a shop, a commercial or for service property, you need also this condominium declaration. And then if you have preemption rights, you need to have a declaration that the seller has to demonstrate that the holders of this preemption right were notified to exercise it and that they have waived that exercise. And here, normally in Portugal, this situation now is a little bit weird. I'm going to explain why. Because there is a new law, a recent law, that states that all the areas considered as urban pressure areas, with all these areas that they say there will be a law that states what is considered or not urban pressure area. In those cases, you need to have you need to notify the city hall and sometimes other public entities to exercise a preemption right. The problem is that they didn't specify what areas are of urban pressure. And because of that, you always have to exercise this. Some notice they consider that you don't have to do it, so there is a big discussion around it. What I advise you is to notify always the city hall, and so that you don't take any risks, because you really don't know what is a urban pressure area or not. And then this other document that it's called infrastructure certificate. This is a very rare document that only when there is allotment permit registered since February 1992, it's needed. So this is very rare. And of course, if you are buying a property that has a mortgage, you must certify yourself that on the moment that you are signing the deed, they have a document issued by the bank or the holder of the mortgage that is really canceling the mortgage. Otherwise, you have then to pay the amount of the mortgage. And you have a toponymic certificate. In some kinds, you need this document, but it's rare also. It's only when you are buying plots of land that you need this. So then you have the taxes that you have to pay when you buy a property. In Portugal, upon the signing of the final contract, you have to pay two main taxes. One is the municipal property transfer tax, we call IMT. This is the higher tax that you really have to pay. And the value depends if you are buying in the mainland or in Madeira or Azores. Madeira and Azores is cheaper, it's not so high. And it depends, of course, of the intended use. If it is for your own permanent dwelling, it will cost less. If it is a second home or for commerce, it will be higher. Sometimes you have an exemption from the payment of IMT. Some properties are considered to be properties of public interests or municipality interests. In those cases, there is an exemption. Or if it is in, we call ARU area, in some cases, you have to pay the taxes. You pay IMT when you buy, but then the city hall will issue a document, because it's it has to comply with some some requests, like it has to be in an ARU area, it has to have a certain level of energy efficiency, and so on. And if it fulfills with all these requirements, then you can have an exemption. The city will issue a document, and then you will be refunded of the taxes that you paid, okay? Of the IMT specifically. And also you have to pay the stamp duty. It's not very high, it's 0.8% of the value. Both taxes, they are the amount you pay. It's going to be calculated over the purchase price or the taxable value. It depends of the higher of the two. It's always leave it on the higher of the two. Normally, it's the purchase price is the one that is higher. I made here a simulation so that you can have an idea of the amounts. So if you are buying a property and the purchase price is 350,000, you will pay IMT, you will pay around 15,000 euros, okay? Stamp duty, 2,800 euros. So the total amount will be 18,237 euros and 94 cents, okay? This is only for you to have an idea. This is if you are buying for your main permanent dwelling in mainland. If you are buying as a secondary residential or to rent as an investment, if it is not for your main permanent dwelling, it will be more or less 1,000 euros. So the total cost will be around 19,208 euros. Okay. So when you are talking about buying a property, the charges and taxes on the property will be, as I said, IMT, stamp duty, and then you have, each year you have to pay IMI, municipal property tax, we call IMI. This is a municipal annual tax. It depends, the value depends of the city, the city council. So you can pay one amount in Caminha, for instance, another different amount in Porto. It's not as high as the IMT. And I believe if you compare it to the States, it's almost nothing. It's not very high. In some cases, you have an exemption, but it's only if it is for your permanent dwelling or if it is a property of, like I said, in the ARU area, and if you are permanent dwelling for the first 3 years, if it is under 1,000, if the taxable value is under 125,000 euros, then you won't pay these taxes for 3 years. And if there is also an additional municipal tax that you have to pay if you own a property or several properties valued above 600,000 euros. You'll need to pay a rate between 0.7% and 1.5% on the amount that exceeds this value. And then upon the sale deed, you need to pay, of course, the notary and land register fees. The notary fees depends of each notary or of each lawyer or each solicitor that will do the document. The land registry fees will be, at this moment, it's 225 euros. And then you have, of course, the lawyer fees and translator fees.